On May 22, 2002, you filed a petition to remove the conditions on residence, Form 1-751, under Section 216 of the Immigration and Nationality Act, as amended. You are seeking permanent residence based on a marriage to a U.S. citizen and filing the petition together with your spouse. On January 7, 2003, you and your wife, Iram Mirza, were scheduled for an interview to remove the conditions on your residence. Your spouse appeared for the interview without any type of identification. The officer conducting the interview then rescheduled you for another date, specifying that your spouse needed to bring picture identification to the next interview. In addition, you were issued an I-72 request for evidence, requesting you to provide documents showing cohabitation and commingling of finances. Our records at this time indicate that you have failed to comply with the above request for documents. You and your wife were requested to appear on March 7, 2003, and March 28, 2003, for an interview in connection with the petition. You and your spouse failed to appear to both rescheduled interviews. On March 28, 2003, the service received a letter from your wife stating that she was not able to attend the interview, and you and your spouse temporarily separated. On January 19, 2005, you and your wife were scheduled for another interview regarding your marital relationship. You and your wife failed to appear for the scheduled appointment. Again, the service received a statement from your spouse stating that your spouse are still separated. Section 216 D.L. of the Immigration and Nationality Act, as amended, states in pertinent part: each petition shall contain the following facts and information: that the qualifying marriage 1. was entered into in accordance with the laws of the place where the marriage took place. 2. has not been judicially annulled or terminated other than through death of a spouse. 3. was not entered into for the purpose of procuring an alien's admission as an immigrant. Marriages entered to circumvent immigration laws are not approvable. See matter of M8INN December 2017, which states in pertinent part, where no bona fide husband-wife relationship was intended, the marriage is deemed invalid for immigration purposes regardless of whether it would be considered valid under the domestic laws of the jurisdiction where performed. You have failed to submit evidence establishing the validity of your marriage and failed to appear at 3 scheduled interviews, which were required to determine the merit of your marriage to Iram Mirza. Since you failed to appear for scheduled interviews, your petition to remove the conditions of residence is being adjudicated on its merit. Although you and Iram Mirza have been married for 5 years, you have failed to convince the service that you shared a life together and entered into the marriage in good faith. For these reasons, the service has denied your petition to remove the conditions on residence, Form 1-751, and your conditional permanent residence is terminated effective December 10, 2001. Sincerely, Robert J. Oken, District Director, Citizenship and Immigration Services, Department of Homeland Security.